5 seconds to go. Start. The law on interference in matters of awards under the 1996 Act has been circumscribed with the object of minimizing interference by courts in arbitration matters. One of the grounds on which an award may be set aside is patent illegality. What would constitute patent illegality has been elaborated in Associate Builders versus Delhi Development Authority, where patent illegality that broadly falls under the head of public policy has been divided into three subheads in the following words. In the 1996 Act, this principle is substituted by the patent illegality principle, which in turn contains three subheads. A contravention of the substantive law of India would result in the death knell of an arbitral award. This must be understood in the sense that such illegality must go to the root of the matter and cannot be of a trivial nature. This again is really a contravention of section 28(1)(a) of the Act, which reads as under: rules applicable to substance of dispute where the place of arbitration is situated in India. In an arbitration other than an international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. A contravention of the Arbitration Act itself would be regarded as a patent illegality. For example, if an arbitrator gives no reasons for an award in contravention of section 31(3) of the Act, such award will be liable to be set aside. Equally, the third subhead of patent illegality is really a contravention of section 28(3) of the Arbitration Act, which reads as under: rules applicable to substance of dispute. In all cases, the arbitral tribunal shall decide in accordance with the terms of the contract and shall take into account the usages of the trade applicable to the transaction. This last contravention must be understood with a caveat. An arbitral tribunal must decide in accordance with the terms of the contract, but if an arbitrator construes a term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of a contract is primarily for an arbitrator to decide unless the arbitrator construes the contract in such a way that it could be said to be something that no fair-minded or reasonable person could do. In Sasang Young Engineering and Construction Company Limited versus National Highways Authority of India (NHAI), speaking for the bench, Justice R. F. Nariman has spelt out the contours of the limited scope of judicial interference in reviewing the arbitral awards under the 1996 Act and observed thus. Stop.